You've been arraigned on a charge in Massachusetts. You get picked up on a new charge. Could you go to jail? Let's talk about that. Hi, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale, which is based on your income. That means that the less you earn, the less you have to pay for our services. So, what we're talking about today is what's called a bail revocation. So let's take the situation. You've been charged with one crime already. You've been arraigned. At your arraignment, the clerk or the judge will have given you a bail warning. They should. They tell you that if while you have an open case, if you get rearrested, you could have your bail revoked and be held in custody for up to 90 days. So let's say that happens. So you've got an open case, you get rearrested. Now the Commonwealth is looking to revoke your bail. That means they want to take away that bail from the first case and have you held in custody. Now, even if you're released on personal recognizance on the first case, PR, that's still considered bail. So a lot of times people say at bail revocation hearings, when they hear about it, they say, I wasn't on bail, so I can't be revoked. Well, you can. Personal recognizance is considered bail for these purposes. So what does the Commonwealth have to prove in order to have you held as a bail revocator? Well, there are three things that are necessary for the Commonwealth to prove. They must prove that you were given your bail warning at the arraignment. Number two, that there is probable cause to believe that you committed a new crime while you were on bail. And number three, that crime and your behavior is such that the community or specific persons in the community are unsafe because you are released, and that no other conditions can ensure the safety of a person or the community at large. So those are the three elements that have to be proven. So a lot of times we get a question, how do you beat a bail revocation, and what happens at a bail revocation hearing? Well, because there are three elements, the Commonwealth has to prove all of them. If any one of them is not present or can't be proven, they can't revoke your bail. So let's take a look at the three elements a little bit more closely. The first one is that you received your bail warning at arraignment. Okay, so what happens is the bail warning is also called an 802 warning. That's just a rule under which that warning came about. And that warning is that while you have an open case, if you get rearrested for any charge, you could have your bail revoked and serve up to 90 days in jail. I shouldn't say serve 90 days. You'd be held up to 90 days in jail without the chance of being bailed out. So that's the thing. If your bail is revoked, you cannot be bailed out. You're stuck in jail for that period of time or until your case is resolved. And one of the injustices in my mind is that if somebody is held on a bail revocation, they've lost their freedom, they've lost their liberty. They are obviously wanting to get their case settled, and they are more likely to accept an unfavorable outcome in their case. So if they plea out to a case, their negotiating stance is much weaker because they want to get out of jail. I mean, who would blame them? So they're more willing to take a bad deal if it means to immediately get out of jail. So they have to show that you were given your bail warning. And how do they do that? Well, on the docket, that's a document that's an official document from the court. And there are entries every time you go to court about what happened, what the date was, and so forth. And on the form, there's a little checkbox for the 802 warning or the bail warning. If it's checked off, that's evidence that you were given your bail warning at the arraignment. It's a very slight thing, and it's almost always checked off. Some very rare occasions, it's not checked off. Sometimes they can't get the document itself, the docket itself, for a number of reasons. If you were not arraigned in the same court where the new case is, they may not be able to get the document at all because it's in another court and they didn't have time to get it, and they couldn't get it faxed over, emailed over, whatever. So they may not have that. That's one way of challenging a bail revocation. There's a case that says there's a presumption that the bail warning was given, even if that checkbox isn't checked. You can assume, the court can assume that it was checked off. Not a lot of people know about that case, and I just assume not the prosecution not learn about that too much. I've had it used on me before, and you try to argue around it, but basically it says, even if you have that one rare case where the check box isn't checked as far as the bail warning being given, there's a way around it for the prosecution. But they have to show that. They have to show that you were put on notice. The second thing is they have to show that there's probable cause to believe that you committed a new crime while you were on bail. So probable cause, very low standard. It's very easy for them to meet it. It's very easy to convince a judge that there's probable cause. Basically, they just read from the police report. If there's an eyewitness, or if there's a police officer that observes something, or whatever it might be, it's very easy for them to show that particular element. It would have to be a very rare case indeed for us to be able to work around it. It has happened, but not often, only because that standard, that probable cause standard, is so low. If your case goes to trial, the burden of proof on the Commonwealth is a beyond a reasonable doubt standard, which is the highest standard in law. That means the jury has to believe to a moral certainty that you committed the crime. Here, probable cause, that's on the very low end of the spectrum, where probable cause is like, yeah, okay, I'm convinced that this person committed this crime. So the third thing is that your crime is one that is dangerous to a person in the community or the community at large. So we can often times argue that the crime that you're charged with, the new crime that is, isn't of such a nature that you're posing a harm or danger to the community. Easy for me to say. So driving on a suspended license, that's probably doesn't rise to that level. Shoplifting, perhaps, may not be to that level. I mean, that can all be argued, of course. If you have a long history of these types of things, that's going to work against you. But relatively minor crimes, we can say to the judge, hey, judge, okay, the bail warning was given. Okay, there's probable cause to believe that he committed this crime while out on bail. But really, the crime itself is not that serious. He's not a danger to anyone in the community, so therefore he should not be held in custody. And the other thing is, as part of that third element, is are there any other conditions that can be imposed short of taking away your freedom that would provide for the safety of people in the community or the community at large? That's where we try to, if it's a bad case especially, we try to offer things to the judge to ensure that the safety of the community while still letting you get out. So things like GPS, stay away, no contact with any alleged victim, stay away from particular addresses, home confinement, that you're released into the custody of another person who will basically take responsibility for you. So those are the kinds of things that we look to on that third element to try to get you released. I mean, the whole battle of a bail revocation is you're going to be held or not held. There's no really in between as far as that goes. So bail revocations, very, very important. One of the ways that you can go to jail at a pretrial hearing, really, because it's more of a pretrial hearing and a new arraignment combined, which would cause that to take place. So watch out if you have any open cases. You absolutely should not get rearrested for anything, because it's they're gonna harp on that right away. That's one of the things they look for. As soon as somebody gets arrested, they come into court. They look at their criminal record to see if there are any open cases. If you have an open case, you're putting yourself at danger of being incarcerated and being held for a period of time, like I said, up to 90 days. And then at that 91st day, you get brought in, if you're still in custody, that is, and then you can try to ask for bail or have bail set, and then you can try to get out. Or you can try to resolve your case prior to that to get out. Like I said, then at that point, we're not working from a position of strength. We're working from a position of weakness, and the outcomes are going to reflect that. So as I say, at Afford Law, we do practice criminal and family law throughout Massachusetts. Our fees are based on your income, so the less you make, the less you pay. We're trying to make ourselves as affordable as possible to the hardworking people of Massachusetts. Please feel free to visit us at affordlaw.org and feel free to book a free virtual appointment with me. I would be happy to answer any questions you might have about criminal or family law matters in Massachusetts. Because at Afford Law, we're making justice affordable. Thank you.